Your Honor.
Hi.
Your Honor, you remember me, right? I remember to the Union Gospel Mission.
Yeah.
Remember, I
have a lot of people at the Union Gospel
Mission.
There are a lot of people who come to court.
So
what happened was
about this, Mr. Wharton.
Mr. Wharton, we're not discussing the case today. Today is not a fact-finding hearing. It's just your attorney's making a motion to continue.
So that we can get the documentation.
Right. I'm trying to move to Arizona right now, and I just don't want to have anything hanging over me in Washington State.
Okay, well, one of the things that's hanging over you in Washington State is you have a warrant out of Kent Municipal Court.
I know that.
Okay, you'll need to clear that warrant before the next hearing. So, sir, do you understand that you're waiving your right to a speedy trial in order to get this continuance?
Yes, this is a really difficult case for me because, I didn't commit these crimes and I was in custody when they both happened.
And it looks like your attorney's going to look into that. That is not the issue today. Okay?
Mm-hmm.
I don't have the information in front of me, and the prosecutor doesn't have the information. So the prosecutor doesn't sound like it's making a motion to dismiss today.
I'm going to go down to the King County Courthouse because last time I was there talking to the lady down there, she verified that I was in custody until January 19th.
And Mr. Wharton, you can keep telling me all these things. It's not going to make any difference today. I'd like to focus on the fact that you're asking for a continuance.
Okay.
Okay, so you understand that you're waiving your right to a speedy trial in order to get this continuance?
Yes, ma'am.
And is that what you want to do today?
Yes.
I'd
like to get this whole thing resolved today.
I understand that. It doesn't sound like that's possible today.
Well, last time we went through this, ma'am, it took less than 3 minutes to pull it up on the computer screen to show that I was in custody.
I'm not the one who's making a motion to dismiss. It's the city, and it doesn't sound like they're satisfied, and they're not willing to do that today.
Mm-hmm. Right. Well, how many guys have a goatee and a baseball hat running around SeaTac Airport? That's what he went off of. That's what the arresting officer went off of.
Mr. Wharton, you can keep arguing with me, and it's not going to make a difference. The city is not moving to dismiss today.
All right.
Before the next hearing, which will be on May 2nd at 10 o'clock in the morning over Zoom, you will need to quash the warrant in Kent Municipal Court. Do you still receive mail at the address? I don't have any address for you at all. Where do you see?
No, I don't.
He's homeless at the moment, Your Honor.
Okay.
I thought he was living at the Union Gospel Mission.
Yeah, that didn't work out very well.
It was supposed to be long-term inpatient is what I remember. So, okay.
It didn't work out very well. I went in there, stayed for a little bit, and then...
Right. I didn't mean to open the conversation, but that was...
Mr. Warren, don't get into it.
Welcome back to Time Served, the channel that's always duplicated, always imitated, but we're too busy to worry about that because we're scanning the docket so you don't have to. I'm Phil, and do we remember this gentleman right here?
You don't hold down a decent job. You're violent towards women, and yet you're a wimp when it comes to standing in front of me. You are a disappointment as a black man. You are a disappointment as a man, period. Again, surely your mother is disappointed in you. You're no good example to your siblings. You've run around and dragged this thing out forever, trying to avoid even being held accountable. You can't even proclaim yourself
Your Honor,
guilty
if I may.
in court.
No, you may not. Okay.
You put in a plea of nolo contendere.
Now, I know everyone remembers the day Father of the Year here, Calvin Flake, took on Mr. Jamil Forbes at his sentencing hearing about the abuse that his daughter endured at the hands of Mr. Forbes, and it was nothing short of amazing. So I'm going to play a little part of this clip, and then I will tell you what happened today.
In these circumstances that programming was ordered, because I think it's definitely necessary. With that, Mr. Flake is present to speak.
Mr. Flake, you may proceed, sir.
There's a great level of disappointment when it comes to dealing with Jamil here. You've been shown to be violent. You've been shown to be arrogant. You've also, the fact that you even showed up in this courtroom with a hoodie on, trying to look like some kind of thug or miscreant, is disturbing. You literally sat up here, sent me a picture, and told me that I must be disappointed as a father, disappointed in my daughter. My daughter, I've never been more proud of. My daughter is strong. My daughter is competent. You rode my daughter's coattails. My daughter is a model. My daughter works hard. My daughter has pulled down an associate's degree. My daughter was dual enrolled. My daughter is a bright, shining light, a source of pride for me. Now, since you want to sit up here and try to talk about my disappointment, how does your mom feel about you right now?
Like I said, nothing short of amazing. Well, today, Mr. Forbes is back at it again. Well, guess what? He was thrown in jail for immediately contacting her right after his probation started. And the best part about today was Dad was in the chat. So if you see the chat log here, so we can see that Dad was in the chat today as Cal Diesel, and he was begging and pleading to get another crack at Mr. Forbes during Judge Washington's court today. Can we stay in Michigan? Mom, and Judge DeSanto has a 2-for-1 deal right here where it involves pew-pews given to kids, a whole lot of drugs, maybe some drunk driving, don't know what else. And then back in Judge Washington, we get a whole lot of back talk and brass knuckles from Amazon from one of these defendants right here. Then poor Judge Sean Perkins had an able-bodied male that didn't know what able-bodied meant, and a mad woman that makes him take a step back and say, dang. As you could tell by her face, it's a doozy. Someone slipped this guy a Mickey in Judge Morgan's court. And then traveling back to Texas, Judge Stevens as nasty as ever. And how long have you been court watching? If it hasn't been long, only on Time Served we travel back in time, where Judge Boyd is doling out justice from the luxury of her home. Don't forget to hit that like and subscribe, set your notifications to all, and never miss the Daily Docket. Court is now in session. Let's roll, nerds!
Doesn't look like it.
He was here earlier. I don't know what else.
Is it the gentleman on the iPhone?
It's on the iPhone.
Right here.
Yeah, there he is. There he is. State your name, Mr. Austin.
Dwayne Osley.
All right. Today is a date and time set for free trial. I've already given you an opportunity to pay the reinstatement fee up front. I mean, to pay that $252, $258 to get a license. It doesn't appear that you've done that. I don't know what more we can do for you, set a trial date or get you an offer.
Basically, like, I get paid every 2 weeks. That's why I haven't paid. I get paid every 2 weeks, and I like try to pay it, try to get a loan from the job, whatever, try to pay it, whatever. But it's still like it ain't working.
Well, you're a young man, right?
Huh?
You're a young man, aren't you?
Yeah, I've been trying to do
side. Able-bodied? Able-bodied?
Huh?
Able-bodied?
Able-bodied.
Yeah.
What you mean?
You got all your health. You don't have any disability or anything, right?
I don't got all my health. I just got hit in a car accident, man. I don't got all my health. My real partner right now, as we talk, I got asthma. And I'm wheezing right now as I'm talking to you.
So you can't get another job, is what I'm saying.
I've been doing like side little jobs, trying to get the money to pay it.
All right. Well, we'll set a trial date. You have October 20th, unless you just want to offer today. What do you want to do?
So, what is gonna be at? What is gonna be like?
We'll wait until
can you push?
Pardon me.
Can you push it to another like not August? You push it like Like,
I'm gonna set a trial date for October 20th. And you'll have, that time to take care of what you need to take care of. And then we'll have some resolution on that date anyway. October 20th, come on back and,
that's 3 days from now. That's basically.
October 20th is 2 months from now.
Oh, okay. I'm tripping. Okay. Thank you.
All right.
All right.
All right. If there's nothing further, sir, have a very good day. Best of luck to you.
Yeah.
Ms. Shanika Green.
Yes,
Did I get the pronunciation of your first name right?
yes.
City of Detroit versus Shanika Green, case number SP 146-62691. Appearance for the record, please.
I didn't hear what you said.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Ms. Green.
Shanika Andrea Green.
All right. Today is the date and time set for a pretrial. You have valid insurance, ma'am?
I had it, but it cut off because of the amount that I had to pay within 2 weeks. I had that LA insurance when you first get it, and then you have to pay another amount within so many days, and I couldn't.
All right. Absolute right to a trial. You need to get a valid license too.
I got driver's license.
I don't know about that.
I got driver's license. My license shouldn't be suspended.
Runner license, please.
Oh, no. Now you about to have me put it up on Secretary of State. No, I have a license.
I would, if I was a betting man, I would bet that you did it. But we're gonna see.
I work in the medical field. I drive my client around. I make sure my
Hey, I'm all right. I'm just, don't shoot the messenger. We'll see.
This is the only ticket that I have.
I just like to make people aware, but I could be wrong.
I work in the medical field. I don't have a record or a driver, no tickets. This is the only ticket that I have.
Okay. Dang. She rolled them eyes, didn't you?
That's an insult when you tell somebody what they don't have and they know their stuff.
I said I could be wrong.
But you are wrong.
Okay, I could be wrong. I hope I am. You don't have to take offense to it.
No, I'm going to take offense to it because you are a black man talking to a black woman and negatively.
I lost the bet. She's got a license. You owe for a no insurance proof $288 and a blocking traffic $210.
From when?
How you can owe for that no insurance proof and still have a license? That's the first time I've seen that.
How long ago
That's
was the
why
ticket?
I said, pardon me?
How long ago was the ticket?
See, that's why I said that I don't believe you have a license. That ticket, because anybody that has a no insurance proof, no matter how long ago it was, doesn't, and they owe their reinstatement fee, they don't have a license. That was back 9/19, 2018. And the blocking traffic, I believe, was on the same day.
So what city?
For Detroit.
I don't even know what that ticket is.
All right.
But I have a license.
I see that. See? She told me. All right. Well, if you get some insurance, I'll dismiss the ticket. If you don't, then $240 fine, dismiss upon payment, amended to improper plate, and you have an absolute right to a trial. What would you like to do?
Improper plates? Hold on. Improper plates.
Let me put you in a breakout room with the lawyer and they can explain
Please
things.
do. I only got one ticket that day. I don't know where no improper plates came from because my stuff is legit.
Well, it's not that legit.
Oh, it's that legit because I don't play with my license. The tickets you just told me about,
you said you don't have insurance? And you drive every day?
Stolen. No, my car just got stolen. I'm not going
to continue.
It was a situation. It was what it was, but I normally pay my stuff. I had
join the breakout room now. Mr. Berry, is that your client?
I believe so, Your Honor.
Have fun.
The criminal contempt of blowing numbers after being placed on alcohol conditions. How would you plead?
Guilty.
I'm going to ask you a few questions. You don't have to answer my questions, but if you don't, I cannot accept your plea, all right?
Yes, sir.
Were you placed on alcohol conditions August 8th?
Yes, sir.
And had you been drinking some form of alcoholic beverages so that you tested positive on August 11th, 2023?
My excuse, I believe somebody spiked me that night.
But you would agree that you did blow numbers?
Yes, sir.
Have I met the statutory requirements? Are you satisfied with the factual basis?
Yes, Your Honor.
I will find the plea is entered understandingly, voluntarily, and accurately given. Now, you had made the comment that you believe somebody spiked your drink. I'm going to remind you that it is your responsibility to make sure that you are aware of what's going into your body. If somebody offers you brownies and you don't know what's in it, you don't eat them. If you have a drink, you don't walk away from it in an area where you don't know the people that might get spiked. You're responsible. You understand this?
Yes, sir. I learned the hard way.
Is there anything you would like to say before sentence is passed on? And I will note this is one criminal contempt. The other one we're not dealing with at this time, correct?
Yeah, yes, Your Honor. We would ask for credit for time served. He has served a substantial amount of time. Release him on a PR bond. He will still have the twice daily PBTs in place, so he will still be accountable to this court.
Now, Mr. Mueller, you reported for your PBTs on the 11th, correct?
The best of my memory, yes, sir. I don't have the paperwork on me. I am planning on getting one of the portable devices, so that way there I know 100% that I am on time and accurate.
All right. At this moment in time, I will grant credit for time served. I will issue a PR bond on the first criminal contempt. Mr. Mott, is there anything else in this matter?
On the record, in the matter of the case of the state of Michigan versus Ryan Jones, 231993, and the state of Michigan versus Scott Hand, 231992. And Detective, your name for the record, please.
Detective Steve Sable, Your Honor.
All right, please raise your right hand. Do you solemnly swear from the testimony you're about to give this matter to be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. You may proceed on the warrants.
Thank you, Your Honor. And on 8/16 of this year, 2023, at approximately 0047 hours, Mr. Hand, defendant 1, was operating his tan 2004 Chevy Blazer in the city of Wyandotte, in the county of Wayne, and he was traveling near the intersection of Biddle Avenue and Ford Avenue when Officer Grote saw defective equipment with no light for the license plate on the motor vehicle while in motion. He effectuated a traffic stop, and Mr. Hand, who was later identified as the operator or driver, while co-defendant, defendant number 2, Ryan Jones, was in the passenger seat. They came to a stop, and Officer Grote made contact with the driver, Mr. Hand. He explained the defective equipment and also could smell a strong odor of intoxicants coming from Mr. Hand and his slurred speech during his contact with him. Mr. Hand said that he had a couple of beverages, alcoholic beverages, earlier in the night. And when asked where he was headed by Officer Grote, Mr. Hand replied that he was coming from Brownstown and going to Carlton, which, by the way, both of those South Downriver communities are both south of the city of Wyandotte. I don't believe he knew where he was at the time. At that time, Officer Grote heard the front seat passenger, defendant number 2, Mr. Ryan Jones, say that he was, in fact, his name was Ryan Jones, also with heavily slurred speech, and he uttered that, "Hey, I got a valid arrest warrant involving weapons, and I sell guns to kids." That was his quote. Officer Grote went around to the passenger seat and asked Mr. Ryan Jones, defendant number 2, to step out, which he did. During a pat down or frisk, a pair of brass knuckles folding knife combination was taken off of defendant 2's possession from his pocket. The total length of the weapon, dangerous weapon, was 8 inches approximately. He was secured and handcuffed by Officer Grote. Then the contact with Mr. Hand continued. He was asked if there was anything inside the vehicle, weapons or contraband, and he was very polite and cooperative and said, "Yes, I got a .38 snub nose in the center console of the vehicle." Officer Grote asked him if he had a CPL, Michigan Concealed Pistol License, and he said no, he did not. Mr. Hand was asked to step out from the vehicle, which he did. Noting before the alcohol, the slurred speech, etc., Officer Grote put him through the standardized field sobriety tests for an investigation for drinking and driving. He ultimately completed the test as required, but failed miserably. Also was asked to submit to a preliminary breath test, a PBT, after his chemical test rights were read to him, PBT rights, and his result yielded a 0.24 blood alcohol. He was also secured and placed under arrest. In the motor vehicle center console were the loaded firearm, several rounds of ammunition, a prescription bottle with Susan Hand's name on it, with miscellaneous pills in the same prescription bottle, in addition to some handcuffs and other items. The two were transported back to the station. Mr. Hand was read his chemical test rights. He consented and gave breath samples, one resulting in 0.22 blood alcohol and 0.21. He was fingerprinted and processed and lodged. While trying to lodge or process defendant 2, Mr. Jones, he became aggressive with the officers. Officer Stromberg and Officer Gardaki had to intervene. And ultimately, he was processed and lodged as well. So to make sure that I hit all the points, the concealed weapons for Mr. Hand, I believe I've accomplished. The weapons, dangerous weapon for Mr. Ryan Jones with the brass knuckle knife combination in his pocket. I believe I've met the court's requirements as well. Operating with a high BAC for defendant 1. Also being in possession of a firearm while intoxicated for defendant number 1. And also his operating while intoxicated. Thank you, Your Honor.
Thank you. Upon examination of complaining witness, I find the offenses charged are committed. There's probable cause to believe the defendants committed these offenses. Okay, and Mr. Westmoreland, Your appearance, please.
Attorney Corey Westmoreland appearing on behalf of Mr. Jones.
Okay. And Mr. Jones, your name, please.
Ryan Jones.
All right. And Mr. Goldpaw, your appearance, please.
Your Honor, John Goldpaw on behalf of Mr. Scott Hand, P30758. This is on 23-199.
Thank you. And Mr. Hand, your name, please.
Scott Daniel Hand.
Okay. All right. And Mr. Westmoreland, as to the arraignment.
Yes, Your Honor. At this time, we are prepared to waive a formal reading. My client stands mute.
And Mr. Goldpaw, as to the arraignment for your client.
Your Honor, he would stand, waive a formal reading of the charges, stand mute to those charges, and ask the pleas of not guilty be entered on this.
All right. And Mr. Hand and Mr. Jones, please pay attention to the rights I'm about to indicate. You each have the right to have an attorney. You cannot afford one, the court will appoint one to represent you. And in fact, you each had an opportunity to speak to an attorney while you've been in custody. Is that correct, Mr. Jones?
Yes.
Mr. Hand?
Yes, ma'am.
You each have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You each have the right to have a trial by a judge or by a jury, and you each have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights, Mr. Hand?
Yes, ma'am.
Do you understand those rights, Mr. Jones?
Yes.
All right. The court's going to enter a plea of not guilty on your behalf. We're going to schedule this matter for a probable cause conference on Friday, August 25th at the 28th District Court. And that will be at 9 a.m. The court has also signed the order for a court-appointed attorney for felony matters as well, for each of you. And Mr. Goldpaw, as to bond for Mr. Hand.
Your Honor, Mr. Hand is 47-year-old. He's a veteran, military veteran. He went through a toxic relationship in Louisiana where he was previously residing. He now lives with his parents in Carlton. Because of his PSD, I'm sorry, he has PSTD. He's going through medication. He's on a list to go to Camp Hope for that PSD. That's down in Texas. He's also filed with the DEA for benefits. Further, he had just been recently diagnosed with early stages of dementia. The weapon belonged to his stepson, who passed away down in Louisiana about a year ago. He was basically brought up with him when he came to live with his parents. He has no prior criminal record. And also, Your Honor, he did have an OUIL back in Louisiana back in 2013. That was resolved. There was a mix-up about some of his reporting, but he has always complied with any court's judgment. We are asking for a minimal bond. He understands the seriousness of these charges. And as the officer indicated, he was quite cooperative with the police. We're asking for a personal bond. Obviously, there is a high BAC and he's deal with felony warrants, but he doesn't have any other prior criminal record, particularly felony.
Okay. And Mr. Westmoreland, before I get to you, I'm just going to finish up with Mr. Hand. Mr. Hand, excuse me, how long have you been in the state of Michigan?
Well, since approximately January 22nd.
Of 2023?
Yes, ma'am.
All right. And the court does appreciate your military service to the country, to our country. And sir, you're not working?
I'm sorry?
You're not working?
No, ma'am. I have no monetary income.
I'm sorry?
My parents, circumstances, and he testifies living with his parents while they help him through his very trying times because of it. As well.
Have you, did you receive any benefits from the VA, sir?
Any benefits from the VA? I believe I was bound. My understanding, he is receiving Medicare, Medicaid, but he has filed for VA benefits.
But he's not receiving any?
Not that he's related
to. Okay. All right, Detective Sabo, as to bond for Mr. Hand.
For Mr. Hand, Your Honor, I think alcohol is really the issue. I'd like to see a moderate bond. It is a serious felony and misdemeanor combination of $10,000 cash and a GPS alcohol tether. Thank you, Your Honor.
All right. All right, the court's going to take into account a number of factors. Number one, the pending charges and the seriousness of those charges. The fact that Mr. Hand, other than his parents, does not have any specific ties here to the community. He's been in Michigan since January of 2023. And the court, for those reasons, wants to ensure the safety of the public as well as the safety of Mr. Hand, and wants to ensure his presence in court. The court does find that a $10,000 here's what I'm going to indicate. I'm going to indicate $10,000 cash bond.
Right, could that be a 10% bond? He has no prior criminal record.
Counsel, he does. He has a prior OWI. That would consider that to be a criminal record.
He has no prior felony agriculture. The prior one was 10 years ago.
The court will indicate $25,000 10% bond.
Thank you, Your Honor.
In the event bond is posted, GPS and alcohol tether to the Wayne County Jail.
Thank you, Your Honor.
All right, and then Mr. Westmoreland adds to Mr. Jones.
Yes, Your Honor, I would like to know that Mr. Jones resides in Brownstown. He currently is collecting Social Security disability, so he's on a very, very limited income. He does not have any other pending matters at this time. He's not currently on probation or parole. And after speaking with him at length this morning, he did indicate to me that he would be appearing all future court dates. He's not a flight risk whatsoever. So I would just ask that this honorable court take all that into consideration when assessing the bond on behalf of my client.
All right, Mr. Jones, you're not working?
I'm not working. I'm on disability.
What's the nature of your disability, sir?
It's I've well, since I was a kid, I have had growth hormone, and also I have really, really great depression and panic attacks, and I have what you call I have seizures.
Are you currently on probation or parole anywhere, sir?
What do you mean by that? Like under probation or? I'm sorry, I didn't understand that.
Yes. Are you currently on probation or parole anywhere?
Nothing, no.
Are you out on bond in any other jurisdiction?
Meaning as in like, can I post bond?
No. Do you have any other court cases that are pending?
No, no.
And Mr. Jones, if you were to test today, what would be detected in your system?
What'd you say? She'll
Mr.
repeat.
Jones, if you were to test today, what would be detected in your system?
Drugs. Oh, no, just my medications.
Medication that you're prescribed?
Yes. Yeah.
All right, what is your rent? You said give money to, who do you give money to for your rent?
Oh, no, I think I must have misunderstood. I must have misunderstood that question.
No, sir, I'm reading from your request recorded for an attorney, and I can't read your writing. Who do you give rent to, sir? Who do you pay your rent to?
Oh, to my mother.
Okay, that isn't what I thought that said. Okay. All right. And sir, do you own any weapons?
No.
Okay. Given Mr. Jones' previous criminal history, the pending charges, the court's going to indicate a $20,000 10% bond. You are to have a GPS teller. The court's going to also indicate both for Mr. Jones and for Mr. Hand, you're not to possess or have access to any weapons or firearms. And you're not to possess or consume any alcohol or drugs that are not prescribed. So Mr. Hand, do you have any weapons?
No, ma'am.
Or firearms at your home?
No, ma'am.
Mr. Jones, do you have any weapons or firearms at your home?
No.
Okay.
No, Your Honor.
All right. And then next Friday at the 28th District Court.
Thank you, Judge. Thank you, Your Honor. Good luck, Mr. Man.
Thank you.
State of Michigan versus Deontay Connors, case number 23 FB 1053. It's a recall.
Rachel McDuffie for the people.
And good morning, Your Honor. May it please this honorable court, Matthew Rosenthal on behalf of Deontay Connors. Deontay Connors, can you state your name for the record, sir?
Deontay Connors.
Thank you very much.
Thank you, Your Honor. We did look over the PSI report, so thank you for giving us time to do so.
You're welcome. Any corrections, deletions, additions to be made to it?
I think everything is correct, Your Honor. The only thing we are worried about is my client does use medicinal marijuana for his spinal issue that he has. Discs in his lower back are contorted, so therefore he gets a lot of pain. He used medicinal marijuana and has a card. From my understanding, it had to be validated through probation or from you, Your Honor. But other than that, that would be the only thing that we would ask the court in question if that would be an issue.
Thank you. He does need to get permission from the court to use any medical marijuana.
Absolutely, Your Honor.
Ms. McDuffie, anything from the people?
Thank you, Your Honor. So I, for the most part, I do agree with the recommendation. And I can appreciate that Mr. Connors doesn't really have, any significant history. My concern is always with insight. And so I can see here, one of the things that kind of stands out to me in any case where somebody says essentially, he was upset, and according to the statement in the PSI that, had that other car not swerved, he wouldn't be in this situation because he wouldn't have ended up in a situation where he was patted down and then the weapon was found. Or when somebody in a drunk driving case says, I was almost home. That's a signal that basically says to me that, I almost didn't have to get caught and deal with this at all, which doesn't really speak to the underlying issue. And here, sure, people may not be advised about the weapon, but it's really not so much about that. There was an underlying sort of anger issue, as far as I can see, which is the way that he responded when he was approached by the police in this matter. That just to advise you, or just to advise Mr. Connors, rather, of a simple sort of traffic thing that may have just been a brief conversation and a warning and let go about a seatbelt, seemed to escalate unnecessarily. So with all that said, I hope that Mr. Connors understands that he's not here because a car pulled in front of him, or he's not here because of the seatbelt. He's here because of his behavior that led up to this point. And I hope that, I don't know if anger management is not something that was in the recommendation, and if the court finds it appropriate, I think it might be good for that to be something that he looks into, because I really it seems to me that that's where all of this really originates from. It's just a little bit of impulse control problems and kind of an outburst there. If that's not something that's necessary, I'm fine with that too, but it's just something that stood out to me. That's all for me.
Thank you.
Absolutely. And if I may, Your Honor, just to talk about Deontay a little bit, I just wanted to ask that briefly, but no, he understands that day, he was driving, dropping his daughter off, his 2-year-old. He was feeling sick at the time. A car kind of hit the brakes. He swerved. He was pulled over and didn't take it well, and he knows that. And he knows that in those situations, if he would have acted more appropriate, more cordial to the police officers, it would have just been a seatbelt infraction and he would have been on his way. He didn't know about the brass knuckles being an illegal weapon, Your Honor. However, ignorance isn't a reason for this not to be charged, and he understands that as well. He had the brass knuckles because he didn't have a concealed pistol license. He didn't want to deal with a gun, and he had those. He did get them off of Amazon, and now he knows he will never, have brass knuckles, but as well have better communication with any authority figure when it comes to police, when it comes to government officials. He is taking a weapons safety course. That is part of the plea. If anger management, is something that we need to look over, I think we can. He just really wants to get this behind him. He does live with his spouse, with the 2 children. He's about to get a promotion, Your Honor, works for U of M. And his promotion's a 6-month placement where he'll be a manager, a manager working as a manager, and hopes to become a manager where he's working now, where he's been working for the last 6 years. He doesn't have any other criminal history. And this was an instance where he does understand that he needs to be more corrective with how with his mannerisms and how he approaches government officials and police officers. But he really wants to put this behind him, Your Honor.
Thank you. Mr. Connors, anything you want to say, sir?
I just wanted to say that the way that the incident happened, I wasn't saying it as if I wasn't saying it in the way that she was trying to make it sound. It was just simple as, if you see a situation like that, why wasn't both vehicles pulled over? I felt like there was no reason why 4 officers should have pulled 1 car over. That's what I was saying. But like the lawyer said, I do understand that I should have came with a better attitude. But I had a lot going on. I had just worked a 16-hour shift the day before, and then I had to drop my daughter off early the next morning. I was literally going home to go sleep and trying to feel better. And then all of this led up to that. It was no excuse. It was nothing. It was just simply, I had a lot going on and it piled up and it came out at the wrong time. And I apologize for that. And I'm just trying to move forward so that way I can continue making the good paths that I've been paving for myself.
Absolutely.
Anything else, sir?
No, that's it.
I did review the police report. I had some similar concerns to the prosecutor and was waiting to hear what you and your attorney had to say. Your demeanor today is concerning to me as well, sir.
Meaning what?
Meaning what I just said. That your demeanor is concerning to me. I think you do have issues with authority figure, because the first thing you did was, once the prosecutor said something, instead of you allocating your regrets, you wanted to actually attack what she had said.
I wasn't attacking what she said. I was defending myself for what she said.
There you go. My point exactly.
I was defending myself.
And now you're giving me back talk.
And he is sorry, Your Honor. This was just a very hard incident.
I really don't think he is.
I promise you I am. I promise. I'm working hard. I mean, I'm going to school. I'm trying to stay on the good path. Like, it was one bad incident.
I agree with all that. I believe all that. It's your attitude, though. That's the problem. And instead of not giving it today, you couldn't resist it. You did it again today. And I was hoping you didn't.
I didn't have an attitude. I don't know if I don't know. I don't have an attitude. I promise.
Anything else you want to say before I sentence you today, sir?
Your Honor, I promise I don't have an attitude. I don't have an issue with authorities. It's just that day it was a really bad day. That's it. I deeply apologize. I'm trying to make the right choices to better my life. That's it. I really am. I truly am sorry. It won't happen again. You won't have any issues with me. I promise. I'm doing everything I can to make the best decisions for me and my kids. That's it.
I understand. I think the problem is that you don't know how to do that, because the best decision today would have been just to be apologetic.
And I am. I apologize. I promise you. I'm sorry for my actions for that day.
Anything else?
I'm not making any excuses. I'm not. I promise. I know that I made a mistake.
There's a sentence of this court, sir, that you're on probation for 6 months. 363 days, 65 days in the Washington County Jail. 2 days credit, 363 days are suspended. You do everything you're supposed to do, then you won't have to do any additional jail time, sir. $725 of fines and costs, $30 per month in probation oversight fee. You must meet with probation when and where directed, including any and all home visits. Make earnest efforts to maintain legitimate employment. Complete the weapons safety program. There's no assaultive or threatening behavior towards anyone else. You're to submit to, pay, and be responsible for random drug and alcohol tests as requested by the court, probation, or any probation officer. No use or possession of alcohol, marijuana, medical, recreational, illegal, or otherwise, unless approved by this court. No being in the presence of anyone having those. No use or possession of any firearm components, ammunition, dangerous weapon, or being in the presence of anyone using those. You must complete an anger management class. And it must be at least, is there a 30-day, Ms. Johnson?
For the impulse control class?
Yes.
There's a 1-day, 4-hour program through Crossroads Recovery.
I'll just do that one. And you also will be under the prosecutor's deferred sentence. I'm going to do a 60-day review to see where he is. October 19th, 2023 at 10 a.m. Sir, you need to contact the probation department after 9 o'clock tomorrow to go over your probation requirements. Do you have the phone number?
I personally, I think I do in the email.
Please call them tomorrow after 9 a.m., okay?
And then, Your Honor, if I may, and I'm sorry, I did not add, and I just wanted that his car was impounded outside of the 2 days that were credited for $450, and he did pay for that. I'm not saying that go to fines and costs, but I did want to put that on the record as well, that he was up to date and paid for that forfeiture as well, Your Honor. And then with the medicinal marijuana, would that be something that's going through probation to validate for use,
Yes.
Your Honor?
It's submitted to the probation department, and then what will happen is they'll submit it to me. I'll review it. I'm looking for the necessity of it so that you know. That's the piece that I look for. Upon submission of it, if I find that there is a medical necessity, I generally approve it.
Thank you so much, Your Honor. And thank you, Prosecutor McDuffie. I appreciate you.
Take care.
And thank you, probation officer. Thank you so much. And that we'll be reaching out to you, and then I'm going to give you a call, Mr. Connors. Thank you, Your Honor, and thank your court staff.
Thank you. Have a good day.
You too, Your Honor.
Thank you. Mr. Forbes, is it true that you are going to waive your right to have a hearing in this matter and admit to the violation? And that you, as soon as I sentence you, make contact with the victim in this particular case?
Yes.
Mhm. So, sir, you sent the victim a text, no, I'm sorry, a Facebook message as soon as you were sentenced in spite of my order to have no contact?
I actually received an Instagram message from her first. I blocked her on Facebook and I got her phone numbers blocked. And I got a text message from her second Instagram account. And I just replied saying, congratulations. Like, you see exactly what I said. I just said, congratulations, like, you got what you wanted. I didn't know that, like, I knew I couldn't initiate contact, but I thought replying, like, I thought if I replied, I wouldn't be in violation. I have no idea. If I would have known that, I would have never replied and I wouldn't have gotten this violation.
All right, I find that there's a knowing and willing admission to the violation of the probation. Are you satisfied, Ms. McDuffie?
With the factual admission that it happened only, yes, Your Honor.
Satisfied, Judge. Thank you. Miss Akiri, I can really, do you have anything to support the fact that a message came to him first? Because the documentation that I have only shows his him hitting her.
Correct, Your Honor. And that's what I informed Mr. Forbes when we first spoke about this while he was in custody. He stated that if he had known, he would have taken his own screenshots. We do not have any screenshots of his side of the messages that were received from him. It just shows the very first message as shown. So no, Judge, we don't have anything to corroborate that. It obviously has been difficult because he's in custody and he doesn't have access to any of his information. And he didn't know about these charges until after the fact, after he was placed in custody or he went into custody.
Ms. McDuffie, anything you want to say in this matter?
Most definitely, Your Honor. So first and foremost, Mr. Forbes, I believe, was under a no contact order. Probably he was under a no contact order or should have been with Ms. Tajane Roberts from his other case, if nothing else. I understand that the case in this one was related somewhat to that, but it was dealing with her father. However, he should have already been under no contact orders with her. Secondly, after he spent the sentencing itself walking around, not really paying a lot of attention to what was being said, but there shouldn't be any confusion whatsoever with what he was ordered to do, because regardless of whether she reached out to him first, which I don't have any reason to believe that she did, he knew he was not supposed to talk to her. Nobody ever specified only initiating contact. And the content of what he said was to immediately victim blame her for him being in this case, in this situation. And as we discussed at the sentencing, he's here for his own actions and refused to take any responsibility for it, even at the time. So to go to that victim with probably not even 15 minutes passing to say, congrats, you got what you wanted, and to suggest that she's somehow jealous of him being with somebody else, just reaffirms everything that we have been concerned about from the very beginning. So it really doesn't matter whether she reached out to him first or not. He knew better than to do what he did. So that's my biggest issue, is that there's still no insight, no acceptance of responsibility for his actions whatsoever. And to stand here today and say that had he known, he wouldn't have done so holds absolutely no weight of water with the people.
It's documented though that she went to take off that no contact with the last case. She went up there herself. And a month prior before sentencing, I have text messages of her clearly stating that she wanted to get back with me, and I was clearly telling her I don't want to. She paid for a hotel a month before sentencing for us and everything. Like, I have all of that proof. And I kept telling her I don't want to be with her no more.
So you're just now admitting to violating the no contact provisions of your bond, because you had a no contact provision in this case then as well.
The no contact in the last case, she went up there and got
Back
the
in this case,
contact
I
order.
don't care about the last case. I can't tell you what another judge is doing. I can tell you that you were ordered by this court starting on January 25th to have no contact with her.
Yeah, and I take full responsibility for replying to a text message, yes.
No, you just said here today that in the last 90 days, which was after January 25th, you were in a hotel with her.
Oh, I said she wanted to get.
Well, how would she know? How would he know?
She texted me. She kept calling me off of blocked numbers, text-free numbers. I have no reason to contact her. I don't want to be with her, and she knows this. I've been telling her since then.
Ms. Ikiriakin, anything else you want to say on behalf of your client?
Your Honor, what we're going to be asking for in regards to sentencing, Mr. Forbes, I think that if this situation has taught him anything, it's that this court is not inclined to accept excuses or games when it comes to this particular situation. Mr. Forbes very much so understands the orders that have been placed on him. He is hopeful that the court will consider a release based on the original sentence. I'm hoping maybe we could do increased classes, something to that effect, Your Honor. That our request today is just in regards to the sentencing, that the court consider not remanding him and still giving him an opportunity to complete probation. I know that this is extremely problematic because he was on probation with the other case. It should be noted that that other case he was found guilty at trial. However, they were able to move forward with the trial without cooperation from the complaining witness in that case. From Mr. Forbes, my understanding is that she was present at the trial, supporting him the whole way, but there was still able to be some type of conviction for the charges based on the evidence that had been presented. I say that to say, Your Honor, that it's a very unideal relationship. I don't want to go as far as to call it toxic because I don't know the details and the intimate details with that.
I don't know how else you could define toxic if this isn't toxic. It's definitely a relationship that doesn't serve either party. Mr. Forbes he's ready to move forward with probation. He's asking that the court give him an opportunity to do probation, to do whatever classes may help him deal with whatever issues he's dealing with that has him repeating these behaviors that finds him in front of the court, especially when it comes to this particular complaining witness. I know it's difficult because Mr. Forbes says that he's taking full responsibility, but at the same time, he's making some type of admission that removes some culpability or responsibility from himself. I don't think that he has fully grasped how his actions are affecting his outcomes. And I think that some classes that could be offered from probation could allow him to see that and help him with accountabilities. They're both young. He's young. I don't have his age in front of me, but that is his primary concern today, Judge. I instructed him. He understands that this isn't a situation that we can take to hold a hearing for, and that he has messed up once again, and he is pleading guilty and ready to take responsibility for that. And we're just asking in that responsibility that the court still give him an opportunity to do probation.
Your Honor, I'm so sorry, but I have a request, so I just need to be able to answer this accurately on behalf of the court. I understand, obviously, this is not sentencing, so we are not in a position to have any sort of victim impact statement. However, as you know, Mr. Calvin Flake, who spoke quite powerfully at the sentencing, is basically asking here behind the scenes that it's, even though there was an admission, there's allegations being made that are sort of evidentiary types of issues. And so if the things that are being raised with the claims of what his daughter did are coming into question with respect to how the court is going to act, he just needs to confirm whether or not he is able to provide any other documentation or speak or address this issue. Since those things, there's an admission with basically allegations built in. So I just need to be able to tell him, no, he is or is not going to be able to speak to the court about this in any way.
We're going going forward with sentencing. I can figure out what's going on here without any additional information.
Your Honor.
Yes.
I believe the father of the victim made a statement that if we can go into a breakout room, I can go into more detail about that.
This particular violation, rather. The main thing that I heard is another opportunity for your client, Ms. Ikiri, I can relate, to accept responsibility and not accept responsibility at the same time. I was very clear to have no contact. And his contact was not only immediate, reactionary to my sentence, but also a re-victimization. Regardless of what anyone else has to say about that, that is my major problem. Whether she contacted him or he contacted her first. The fact of the matter is that in retaliation for what I did, he made comments that were intended to re-victimize despite everything I just said to him within less than 15 minutes. It's a direct and blatant disregard of my order. And if he wasn't already on probation, would be contemptible. I agree with you that your client needs classes. He's going to start those classes in jail. Is he in MRT or anything like that while he's in custody right now?
I'm in MRT.
How long have you been in that?
I got in, I think, I want to say like a week or like a week and a half when I came in. And I'm like, I've done 10 sessions already. And we can do, it's like Monday and Friday. And I'm on like my 10th session right now. Tomorrow would be my 11th session.
I'm wondering if you're learning anything.
I'm learning a lot. It's definitely like opened my eyes to like a lot of like childhood stuff too. It's like probably caused me to like act and think a certain way and handle certain situations. It's definitely opened me up. I say that a lot.
So, this charge here is a 100, is it a 180 or a 90-day max? Let me see where we are.
180, Your Honor.
And I initially gave you what, upfront 90 days?
Yes.
That was on July 6th. So you're going to serve an additional 15 days at this point for the violation. I believe that the MRT program is a 6-month program in the jail. If you violate again, if you have any contact in any way, shape, or form, through you, through a third party, through anyone else, you're going to be looking at just doing the time Do you understand that part?
Yes, ma'am. Trust me, I won't have any type of contact, reply, or nothing.
All right.
I have one question. So you said, so my out date was the 19th of next month, so it would be that plus 15 days?
That is correct.
Okay. And then I just gotta complete MRT when I get out?
There is there was a long list of things you need to do when you get out, sir. You're
Okay.
gonna need to contact the probation department when you're done, and they'll go over that list of things with you so that you are clear on what needs to be done. Okay? You'll finish the MRT when you're out if you don't do anything else while you're in there. Okay?
And I'll just go to community corrections right up here?
Correct. Exactly. All right. Thank you.
Thank you, Your Honor.
Yes, Judge, we're ready on Jacob Brown. It's a PSI.
All right. Who's the prosecutor on this?
It should be Marcus.
Brenda, you're ready?
I'm ready.
All right, everyone, if you're not a part of this hearing, I'll need you to please mute. Court is calling 2020 CR 0430, State of Texas versus Jacob Christopher Brown. If I have parties announced for the record, please, for the state,
Marcus Sanders for the state.
for the defense.
David Andre Wooder for Mr. Brown.
And are you Mr. Brown?
Yes, Your Honor.
All right, we're proceeding by video because of the pandemic. Any objections from the state?
No objection.
Any objections from the defense?
No, Your Honor.
All right, everyone, I'm sorry, just give me a moment, please. Chance to review the PSI report. State,
Yes, Judge.
defense.
I have, Judge.
Okay, are there any objections to the PSI report? State,
No, Judge.
any objections to the PSI report from the defense?
No, Your Honor.
All right, then state you're opposed to the defendant's application to deferred adjudication. Why?
Judge, so initially our opposition was for a couple reasons. We had a victim who initially was cooperative. His version of the facts is slightly different, or is different than what's in the PSI. And so I guess reading what's in the PSI sort of made me change my overall view of the case. I guess ultimately we would still be opposed just because Mr. Brown was already on probation at the time that he committed this offense out of Wilson County. And then after this offense, he picks up another misdemeanor theft where he stole from someone he knew. So we know
Okay,
that.
I don't understand. You said, I'm sorry, I didn't hear you, and I don't think it's put in. You said after this case, he picked up a misdemeanor theft?
Yes, Judge, there's a misdemeanor theft that we agreed to TIC for his plea on this case.
Okay, so let's talk. You were saying that after reviewing the PSI report, it made you think differently. Can you explain that to the court?
Yes, I guess what we were told by our victim was that he, I guess, was just like a good citizen who was helping out at-risk youth. And so based on that and the fact that this defendant and his co-defendant took advantage of the situation, that's why we were opposed. The PSI says that they were in a relationship. And so we don't have a victim to speak to ask him about that, but it was the first that we've heard about it. And so that's what.
Wait a minute, you said something about a relationship?
Yes, Judge, the PSI states that the defendant and the victim were in a relationship.
When you say relationship, what do you mean?
And they were a couple, a romantic relationship.
Okay. All right. So, Mr. Woodard?
Judge, if I may, it appears that Jacob has been in custody on this case since October 25th of 2019. He's been in continuous custody. And as Mr. Sanders mentioned, at the time of this offense, he was on deferred adjudication out of Wilson County for a less than a gram case. Looking at the PSI, it appears that the probation department in Wilson County is going to withdraw their MTR as soon as this case has been resolved. The facts of the case are portions of the facts that Mr. Sanders is mentioning regarding a relationship is the complainant and my client were in a dating relationship when this offense occurred. Looking at the PSI, it does not appear that the PSI officer was able to make contact with the complainant to get their version of what they want to see happen to Mr. Brown, which I think is important. Usually when you have a case of this magnitude, typically the complainant has a voice and they want to make sure the prosecutor in the court knows their voice. But in this particular case, the complainant has not made contact with the PSI officer. I think they've stated they made numerous attempts to call and text them. So there is no opinion right now from the complainant on what they want to see happen with Mr. Brown. What I would place before the court is that he does have a minimal criminal history. At the time that he picked up this offense, he was on deferred for a less than a gram. And then he also has a misdemeanor theft case, which Mr. Sanders is going to TIC in consideration for this plea. But aside from that, this is the only thing he has going is this aggravated robbery, which he has taken responsibility for in terms of his plea. Looking at the TAP evaluation, Mr. Brown has dealt with some substance abuse issues with alcohol and also with methamphetamine. The TAP evaluation is recommending inpatient treatment. What I would recommend to the court, because he's been in custody so long, since almost a year and a half, we're looking at since he's been in since October of 2019, if the court does grant his application, in light of placing him in inpatient treatment, since he's been in continuous custody for so long, if the court would consider intensive outpatient treatment. Of course, I can't vouch the fact that he's been sober while he's been in jail, but I will go out on a limb and say that he hasn't had access to alcohol and also to methamphetamines while he's been in there. He does realize that he made a mistake, bad choice that night when this offense occurred. He's accepted responsibility for that in terms of entering his plea. And we're just asking the court to consider his application and grant his application.
All right.
Okay, so here's my question. What does the fact that he was in a romantic relationship with the complainant have to do with this case?
Well, I think it's somewhat changed. I think it changed the facts of what that complainant initially told to Mr. Sanders when they were evaluating the case. The complainant alleges that they were not in a relationship. He was just trying to help Mr. Brown and the co-defendant out. And that's, in my opinion, in my evaluation of the case, that was never the facts. It appears that Mr. Brown and the complainant were in a relationship and things got out of hand that night. They were going to a motel to spend the night and things got out of hand that night in that vehicle. And the facts speak for themselves. An aggravated robbery happened, but it wasn't a stranger on stranger type of case. It wasn't the fact that Mr. Brown is taking advantage of this person. It's that they're in a relationship, and like relationships sometimes happen, disagreements happen, and it escalated to a point where it shouldn't have escalated to.
Okay, because I don't think anybody on this screen, and when I say anybody, I mean defense attorneys and prosecutors who have had relationships escalate to an aggravated robbery. So I'm trying to wrap my mind around how the fact that they were in a romantic relationship, how that translates to him, to the fact that you feel he should receive deferred adjudication.
And Judge, the reason I'm asking for deferred adjudication primarily is because he has a limited criminal history. He has no violent criminal history at all. The only prior case that he has is a less than a gram. And then, of course, he has a misdemeanor theft case. So it's not like he has a history of assaults, a history of criminal mischief, history of any type of violence. In my dealing with Mr. Brown, and I can only vouch for our relationship that I've had as an attorney with him. He doesn't strike me as a violent type of person. He does admit in the PSI that he was under the influence. And of course, some people who are under the influence behave differently than they normally would. And I think that exacerbated what happened. Him being under the influence of alcohol and substances at that time. I think the relationship fact is, people behave differently in relationships. No, I haven't escalated to the point where I've committed an aggravated robbery, but other people behave differently in relationships and also when they're under the influence of drugs. And I think that's what happened with Mr. Brown.
All right. And State, have you had any contact whatsoever with the complainant in this case?
We did initially, Judge. He was really responsive. His stance on it was that he wanted prison because of the version that we were told, that he was trying to help the defendant out and they took advantage of him and robbed him. We informed him that a plea was approaching on this case and the co-defendant's case, and then that was the last that we heard of him. We've tried on multiple occasions, at least 3 or 4 different times, to call and text and haven't heard any response.
All right, Mr. Brown, is there anything you wish to say?
I would just like to say that I know that
just 1 second.
I'm sorry.
If you could raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, so you can lower your hand. Defense, would you like to ask him any questions?
Well, I guess the only question I would have is, Mr. Brown, I know the judge asked, did you have anything that you wanted to add to what I've said and also what Mr. Sanders has said? Is there anything you want to add to the court to let them know about this incident, about what you want to happen regarding your application for deferred adjudication?
Just that I know that I made a mistake and I let the situation get out of hand that day. And
No. Let me stop you right there.
Yes, ma'am.
You didn't make a mistake. You made a choice.
Yes, ma'am. I know I made a wrong decision, a choice to do something that I shouldn't have. And I just hope that the court will take into account that I have never done this before, and I just don't want the rest of my life to be a product of one bad choice that I made, and that I can be a productive member of society if I'm just given a second chance. That's all, Your Honor.
All right, any questions from the state?
No, Judge.
All right, I'll hear argument.
Judge, ultimately, our stance is we're still asking that you deny his application. He's been given a second chance. He was on probation out of Wilson County, and he still committed new offenses. And so we don't think that he would be a candidate for probation.
All right, defense, any other argument?
No, Judge, not aside from the arguments that I've already presented before the court, but I would like the court to strongly consider how long he's been in custody as part of his punishment on this type of offense. He's been in since October 25th of 2019. I do believe he can be a productive member of our society. Of course, if he gets a felony conviction of this type, it's an uphill battle. It's already an uphill battle because he already has the probation case in Wilson County. Then he'll have, if the court does grant his application here, he'll have another felony case that he's dealing with. But we're just asking the court to strongly consider that application. And also the facts of the case. I don't believe, and I don't want to misspeak, but I don't believe the complainant received any types of injuries. I don't think that he was actually injured during the aggravated robbery. I would like the court to consider that also.
All right, Mr. Brown, I only know you based upon what I've received in the form of police report and PSI reports. You know you better than I know you. better than your defense attorney knows you, better than the world knows you. And how old are you?
24, Your Honor.
All right, and right now you probably know yourself better than your parents know you.
Yes, ma'am.
So I don't know whether you would be great on probation. So far, you've proven to me that you won't be great on probation. But here's your quandary, and I'll give you a decision to make. I can give you 10 years deferred. However, if you are revoked on that, you're looking at life in prison. Or you can take the 5 years now. Once you complete the 5 years, you're not on probation, you're done. So what do you want to do? But know that if I give you deferred adjudication and you mess up on it, that means that you violated conditions that I've given to you. You're subject to the full range of punishment.
Yes, ma'am. I would like the 10 years deferred, please.
Okay. All right. And let me just tell you this before you 100% say yes.
Yes, ma'am.
People will say that when they're in custody. And they say that because they're like, I promise you, I'm going to do great things. I'm going to do everything that you're asking me. And it's because at the point in time, they're feeling the weight and the pressure of being in custody, and nobody likes being in custody. I guarantee you, nobody there wants to be in prison or in orange, right?
Yes, ma'am.
So they always promise that they're going to do everything that's asked of them because they don't want to be in custody. But I'll give you 10 years deferred, but I'm telling you right now, the way you felt when you came before me and you thought maybe I'm going to be doing 5 years in prison and preparing myself for that. Every time you make a decision while you're on probation, you need to be thinking, is this something that I could get revoked for and spend life in prison?
Yes, ma'am.
You understand?
Yes, ma'am, Your Honor.
So when you look at the decisions you're going to be making, your bad decisions that you make could turn into a horrible decision, which may result in you going to prison for life.
Yes, ma'am, Your Honor.
All right, I'll sentence you to 10 years deferred adjudication. There's an affirmative finding of deadly weapon. Take in consideration 626220. There's going to be intensive outpatient treatment with probation. Weekly Zoom reporting until further notice.
So I have another court date on April 8th.
Where are you going to be living?
With my mother at 6300 Rue, Maryland.
6300 what?
Rue, Maryland, RUE space MARIELYN.
And what's your mother's name?
Bobby Faulkner, BOBBIE FAULKNER.
Defendant to reside at 6300 Rue Marion Lane with Bobby Faulkner. There's going to be GPS, waive fees, defendant allowed to work. I'm going to want field visits. How far did you go in school?
To the 9th grade.
Why do you only have a 9th grade education?
We moved around a lot growing up, and so I was put in homeschool, and then I just never completed it.
There's going to be 250 hours of community service restitution. That'll be waived if he obtains GED or trade school certification. And the court is going to require you to obtain your GED or some sort of trade certification. And there's to be proof of employment within 30 days of release. Restitution and no contact with Taj Matthews and Martin Rodriguez. Rebecca, is there anything else he needs?
Are you gonna do a random drug test?
Yes, random UAs.
And Judge, the other co-defendant, I would ask that a no contact be put in for
Yes, and who is the co-defendant?
Julian Barrios, Berrios.
All right, and there's to be no contact with Julian Barrios. And there's to be no employment with vulnerable persons. That means that you can't be a home health care provider. You cannot be babysit children or anything like that. Do you understand?
Yes, ma'am, Your Honor.
And I'm going to give you my speech about ninth grade education. Education in the United States is free. People come from foreign countries, not speaking the language. They come here high school age. They end up coming to a high school and becoming the valedictorian or first in their class. That's just laziness from people who were born here. So stop being lazy. Stop making excuses. At some point, it is no longer your parents' fault that you only have a ninth grade education. You understand?
Yes, ma'am, Your Honor.
So you're at an age, it will no longer be acceptable for you to blame your parents for what's going on in your life. And I'm going to give you a curfew, and that curfew is going to be 8 p.m. So, you understand?
Yes, ma'am, Your Honor.
So when street lights come on,
So I won't be able to work overnight anywhere?
if you provide proof to probation that you're actually working, yes.
Okay, and if.
But for now,
Yes, ma'am.
8 p.m. is your curfew. When you had better be in that house before the street lights come on. Do
And
you
if my,
understand?
if my address changes for any reason, I just let my probation officer know that?
Yep. See, look at you. You're already trying to,
No, I just want to make sure that I haven't, so I don't violate my probation for any reason.
well, and let me just tell you another thing. You're living with your mom.
Yes, ma'am.
So legally, you're an adult, but you're still acting like a child because you can't support yourself. So whatever your mom says in that house goes.
Yes, ma'am.
Keep your room clean. Help her around the house. Wash dishes. Try to figure out some way to earn your keep. You understand?
Yes, ma'am.
I'm showing you a document entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you electronically sign it?
Yes, ma'am, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am, Your Honor.
All right, good luck to you. I'm going to send you to a breakout room. Probation will go over conditions with you.
Thank you.
And Mr. Woodard, I'm going to send you to a breakout room with your client. To breakout room number 5, and probation will meet you there. Just one moment.
Okay.
And everyone, give me a moment, please.
Another thing,